Morning, everybody. It's just 10 o'clock, so hopefully everybody has now been able to join us. I'm going to make a start. So good morning to everybody who has joined us today, and thank you for attending and welcome to our webinar. This webinar today is part 2 of a series of webinars for principals covering topics on commercial agency law. My name is Suzanne Carr. I'm one of the partners in the commercial litigation team here at Myerson, and I'm joined today by Robert Brothers, who is an associate in the team. We are both specialists in commercial agency law, and we undertake work for agents and principals on a day-to-day basis. So just before we make a proper start, and just by way of a few housekeeping matters, we will record the webinar today and circulate it afterwards to everyone who's attended, and it will also be posted on our YouTube channel. We will have a question and answer session at the end, so please do post any questions you have on the Q&A function, which you'll find at the bottom of your screen. We do have our digital marketing manager, Stu, in the background today, and he will be monitoring the questions that come through. And at the end of the session, Rob and I will endeavour to answer as many of the questions as we possibly can. We anticipate the presentation will last around 30 minutes. Bear with me, I'm just going to change slides. Okay, so moving on to the agenda for today. First of all, we'll just have a very brief recap of what we covered in part 1 of the series. We'll run through a summary of an agent's entitlements upon termination of the agency. And then the main part of the webinar today is the practical guide for valuing agency claims. We'll then have a brief look at low earning agencies and how those type of agencies are impacted when it comes to an agent's claim for compensation. And finally, a brief look at the liability of principals to sub-agents. If there are any questions on the back of the webinar which might be specific to your particular business, then please feel free to contact either me or Rob after the webinar, and we'll be delighted to discuss those separately with you. Okay, so in part 1 of the series, we looked at various topics relating to the regulations and an agent's entitlements. So I'm just going to recap on the key points before we move on to the main part, which looks at valuing an agent's claim under the regulations. So the commercial agents regulations are a piece of English law. They're enacted into English law, but are derived from the EU directive on commercial agency law. The English regulations are mandatory, so that means they cannot be excluded in their entirety by agreement between the parties. Now, not all sales agents do have the protection of the regulations. An agent is only afforded the protection of the regulations if they meet the criteria or the definition of a commercial agent. Critically, that requires the agent to be independent of the principal. The agent will be authorised to sell the goods on the principal's behalf and not in their own name, and they'll be remunerated for doing that. And the remuneration usually takes the form of commissions based on the value of the goods sold, or by way of a retainer, or sometimes a mixture of both. Agents have various rights under the regulations, and that includes the right to receive a minimum period of notice before termination, the right to receive information and documents, and that is to enable them to properly perform the agency. They have a right to receive a written contract upon request, although in practice we tend to see that that is a right which is exercised very sparingly. There is a right to be paid commission on orders which are attributable to the agent's efforts, and then various entitlements which arise following termination of the agency, which we're going to explore in more detail later in the webinar. It's important to say also that principals are protected under the regulations. It's not just agents, but this is to a more limited extent. So agents do owe their principal a duty of good faith and a duty of cooperation. So importantly for the principal, this means the agent must comply with the principal's reasonable instructions. So I mentioned a short while ago that the regulations are mandatory and can't be excluded in their entirety. But it should be noted that it is possible to contract out of certain parts of the regulations by agreement between the agent and the principal. This agreement to depart from certain aspects of the regulations will usually be recorded in a written agency agreement. For example, it might be possible to contract out of an agent's entitlement to pipeline commissions following termination. This is often an area of contention in agency claims, and the reason for that is because the right to exclude Regulation 8 or the right to pipeline commissions hasn't been decided by case law. So the position isn't clear, and unfortunately, like with many aspects of the regulations, this does give rise to arguments on both sides. The parties can agree to vary the terms of an agency agreement, and this was something, again, we looked at in part 1, but it's important that principals take care in how they go about this. It's important to ensure the agent has given their consent to the variation and that the agreement should be recorded in writing if at all possible. And the reason for that is that it will reduce the possibility of any dispute arising later down the line, both as to whether the agency has been varied at all, and if so, on what terms has the agency been varied. I think it's fair to say that many of the disputes we see, unfortunately, arise because there is a lack of clarity, a lack of evidence recording what the parties have agreed, and that just by its very nature gives rise to disputes. So part 1 of the series, which also included our top tips for principals, does remain available to watch via our website and YouTube channel if you haven't already seen that, and we will add a link into the group chat today so that you can access that if you would like to do so. Moving on to an agent's entitlements following termination of the agency agreement. So when a commercial agency is terminated, various entitlements arise for the agent. And in practice, we find that the majority of disputes tend to concern the value of these claims, how much the principal is required to pay the agent after the agency has come to an end. The entitlements fall into 4 main categories, and those are pre-termination commissions, post-termination commissions, and those are often referred to as pipeline commissions. Then there is the minimum statutory notice period, and then finally, compensation or indemnity. I'll look at each of those in turn. The pre-termination commissions is an entitlement under Regulation 7. And this is an entitlement to be paid commission on orders which have been concluded during the agency. And that includes orders that have been received by the principal but haven't yet been paid by the customer. To claim commission under Regulation 7, importantly, the transaction must have been concluded because of the agent's efforts, and that's generally within the territory of the agency or customers that are exclusive to the agent. Then we have Regulation 8, and this governs pipeline commissions, which fall after the agency has terminated. So this gives the agent a right to be paid commission on orders concluded after the agency is terminated rather than before. Rob will talk shortly about this entitlement in much more detail. But in summary, the entitlement is to be paid commissions on orders concluded within a reasonable period after termination. And the agent has to be able to show that those orders have been concluded mainly as a result of his efforts whilst he was an agent. If the agent can show that the orders are mainly attributable to his efforts and they fall within the reasonable period, then the agent will be entitled to commissions on those orders. Regulation 15 is a right which is often missed by principals, and that's the right for the agent to be given a minimum statutory notice period. That period is between 1 and 3 months and depends on how long the agency has been in existence. It is just a minimum period, and the agent and principal can agree by contract to extend that period if they so wish, but they can't agree to shorten it. If the principal doesn't give the agent the minimum period of notice, then that will give rise to a damages claim by the agent for the period for which notice has not been given. And Rob will talk about valuing that shortly. Regulation 17 is probably the most important of the agent's entitlements, which is the right to receive a termination payment, which can either be compensation or indemnity. This right is usually the most valuable element of an agent's claim, and that means it does require careful consideration. If there is a written agency agreement in place between the parties, this will often stipulate which of these two entitlements is going to apply on termination. If the agency agreement states that an indemnity applies, then the indemnity entitlement will apply. However, often agency contracts are silent on which option is going to apply. And so the default option is compensation. So in summary, if the parties haven't agreed which option will apply, it's going to be compensation. And it's only where the parties have specifically agreed to have indemnity in place that will apply. The consequences of which option has been chosen are significant because the two options, the two types of claim are calculated very differently. In very general terms, it's fair to say that the compensation option will attract a higher payment for the agent, whereas the indemnity is going to be usually more favourable for the principal. And the simple reason for that is because the indemnity is capped, so there's a maximum amount that can be paid under the regulations, whereas there is no limit on the amount of compensation to which an agent can be entitled. Moving on to the next slide, I'm just going to cover the right to an indemnity or compensation and when a principal is liable. So this right arises upon termination of the agency, but there are some limited circumstances when the agent will lose this important right to be compensated or indemnified. So just look at each of these in turn. The principal will not have to pay compensation or an indemnity in the following circumstances. So if the agent terminates the agency, him or herself, or if the agent has been terminated by the principal because of the agent's serious breach of the agency, or where the agent has assigned the agency to another agent, although the assignment point is not a common scenario in my experience. However, there are various limited exceptions to the rules that I've just mentioned. So the first point where I said the agent terminates the agency, him or herself, they're going to lose the right to compensation or indemnity. That won't be the case where the agent has retired on the grounds of ill health or has reached reasonable retirement age. In both of those circumstances, the agent will still be entitled to be paid compensation or an indemnity. Secondly, if the termination was on the grounds that the principal was in serious breach of the agency, provided that can be proven, then the agent will remain entitled to the termination payment. In the case of an allegation by the agent that the principal was in serious breach of the agency, or what is in legal terms called a repudiatory breach, this should be considered very carefully, and we would always recommend in these circumstances that the principal seek legal advice. Often we see agents making this allegation, but it's not necessarily the case, and it has to be closely examined so as to determine whether in fact the agent did have grounds to terminate the agency on the grounds of the principal's repudiatory breach. If the principal can show that the agent did not have the grounds to terminate on that basis, then the principal will be able to avoid paying compensation pursuant to Regulation 18. Another important point is just to say that the right to indemnity or compensation will be lost if the agent fails to notify the principal of the intention to pursue this right within 1 year of the termination of the agency. There is no formal formality as to how that notice needs to be given. The agent simply needs to notify the principal in some way or another that the claim is intended to be pursued. So I do hope it's apparent from this overview that it's really important for a principal to be able to identify, first of all, which of its sales agents are likely to be afforded the protection of the regulations, and to have a basic understanding of the claims that an agent may have in the event that the agency is terminated. By having that understanding, that will enable the principal to be informed as to its potential exposure upon termination, and hopefully will be an indication as to when legal advice should be sought. That brings me to the end of my section on agents' entitlements and leads me nicely to hand over to Rob to discuss the practical aspects of valuing an agent's claims upon termination. Thanks, Rob.
Thanks, Suzanne. I'm going to give you a brief guide on valuing an agency. So as you can see, there's various limbs for a principal to consider when valuing an agency. So this is simply intended as a high-level summary, but if you do have any questions after the webinar, you can of course contact me or Suzanne, or leave a question in the Q&A. So we've discussed the entitlements an agent has the right to claim on termination of the agency. For the purposes of my valuation guide, I'm going to presume the agent is entitled to claim compensation and indemnity, and none of the exceptions Suzanne has just discussed apply. So as a starting point, it's helpful to consider each component or each claim separately. So we'll start with pre-termination commission under Regulation 7. So that should be uncontroversial, and as a principal facing a Regulation 7 claim, you should be simply required to pay the agent commission on transactions concluded up to the date of termination. And I would say so long as the principal pays the agent the commissions owed under the terms of the agency contract or terms agreed with the agent, if there is no written contract, then there shouldn't be a dispute here, and it should be relatively straightforward to calculate and settle. However, where a dispute might arise is where an agent claims they've not received commissions on specific transactions in their territory, which they feel they ought to have, where there's a dispute regarding the extent of territory, or if there's a disagreement about applicable commission rates. that can lead to an agent bringing a claim for damages under Regulation 7. So that's just something to be aware of when dealing with these types of claim. So next we've got Regulation 8, pipeline commission or post-termination commission. The calculation of that is somewhat more complicated. So as Suzanne's discussed, on termination, the agent has the right to claim commission on orders placed after termination, where that order is mainly attributable to the agent's efforts during the agency and for a reasonable period of time after termination. The term mainly attributable is rather vague, and in practice, the question of which sales are mainly attributable to the agent or not is often disputed. However, the underlying purpose of pipeline commission is clear. It's to prevent the agent from being deprived of commission on orders concluded because of their efforts, simply because those orders have concluded after termination. So if an agent has worked extremely hard in generating an order before termination and the order only concludes after, then the agent has grounds to claim pipeline commission. What's perhaps less clear is a situation where the goods sold are complex and the lead time between presentation and a concluded transaction is several months or years. A principal could argue that whilst the initial work was done by the agent in presenting the product, the principal had to do most of the important work either before or after termination to secure the sale. So really, claims for pipeline commission are very fact specific. Also, I would say rather unhelpfully, there's little guidance on what a reasonable period is. That's the period of time where orders ought to be considered for the purposes of pipeline commission following termination. Depends really on the type of product sold, the lead times, complexity of the product, and how the product is sold to the customer. Agents generally argue a reasonable period of 6 to 12 months applies. Principals will typically argue that a shorter period applies. There's no hard and fast rule, and it's usually a matter for negotiation. Practically speaking, the calculation of pipeline commission requires an analysis of orders which the principal receives after termination. However, if the agency's only been terminated and those orders haven't materialized yet, then looking at past sales performance and levels of commission earned by the agent can be indicative of future sales and can help with estimating a pipeline commission entitlement. Assuming the relevant sales information is available, you'll have to consider what orders can properly be ascribed to the agent. And again, that's likely to be very fact specific. And just in practice, I'll touch upon a common problem where there is really no easy answer, and that's in relation to reorders or repeat orders from an established customer where no one in particular exerts an effort to sell to that customer. In that scenario, an agent will often argue if they originally signed that customer up to the principal, then any reorders after termination of their agency are by default mainly attributable to them. However, you might distinguish between scenarios where an agent sells a new range of product before termination and a customer places further orders after termination. In that scenario, the entitlement to pipeline commission probably would arise, given the agent has made efforts to sell and promote a new product range. However, if a principal's product range is relatively stable and the customer simply orders as and when stocks of items are low, then I would certainly argue the agent is not entitled to pipeline commission on such orders. So as Suzanne discussed previously, agents are entitled to receive minimum notice periods. They have to expire at the end of a calendar month, and the length of the notice depends on the duration of the agency. So just by way of a short example, Stephen Smith is an agent and has been an agent for 5 years. He's been given notice of termination on the 1st of June 2023. Since the duration of Stephen's agency exceeds 2 years, he's entitled to receive 3 months' notice, and that has to end on the 30th of September 2023. So if Stephen hasn't been given his full notice, he's entitled to bring a claim for damages for loss, which would be his net loss of earnings during the 3-month notice period or whatever notice period he's been deprived of. It's important to note here that Stephen is only able to claim his net loss. So any damages he claims has to be calculated net of expenses. And this is really something that's often missed in my experience when agents present their claims. So it's just something for principals to be mindful of. Finally, turning to compensation and indemnity. So let's deal with indemnity first. So we've considered the circumstances in which an agent is entitled to an indemnity, and that's when the agency agreement states an indemnity applies. The calculation of indemnity is relatively straightforward. It's designed to compensate the agent for continued benefit, which the principal derives from an agent's efforts after termination. And the court only awards it when it considers it's equitable in all the circumstances, which includes consideration of commissions lost by an agent or on business transacted with customers. So one thing to note from the beginning is that in practice, when an agent is asserting an indemnity claim, they'll typically claim that they're entitled to 1 year's commission based on the average of the last 5 years. That's not strictly correct. What the agent's done here is calculate the statutory cap that applies to indemnity claims. So whilst it's correct that the statutory cap is calculated as an average of commissions in the last 5 years, that's not the agent's entitlement. It's simply the maximum that the agent is entitled to claim pursuant to the indemnity rules. So the actual calculation of indemnity is more involved, and I'll take you through the basic formula, which is as follows. So the principal should identify the customers the agent has introduced to the business whilst as an agent, and existing customers where the agent significantly increased the volume of business. And once you have those two customers, identify the turnover produced by each of them in the last 12 months prior to termination of the agency. Identify then the gross level of commissions the agents earned in the last 12 months. Factor in how long it's likely the business of those customers will last. 2 to 3 years is a general guide, although for negotiation purposes, an agent will argue a higher period and the principal will generally argue a lower period. Make a deduction then for the level of migration of existing customers, which is to reflect the fact that even steady customers might cancel their business with a principal. So you might take a migration rate of up to 25% per year as a general guide, but the principal will need to consider customer loyalty in line with the overall business. You make then a further deduction for expenses of the agent and for receipt of an accelerated payment. And then you should have your indemnity figure. And then you apply the statutory cap. And then finally, consider equitable considerations such as levels of remuneration, decrease in company's turnover, existence of restraint of trade clauses, etc. So the key takeaway here really is generally the statutory. It's generally the statutory cap the agents refer to in initial negotiations, since it's very easy to calculate. However, it's important for principals to appreciate that a proper calculation of an indemnity needs to be undertaken, because it could be the case that the indemnity, once you run the calculation, is actually lower than the statutory cap. So turning now to compensation, that is a different calculation altogether from indemnity. It reflects, in principle, the value of the agency business as at the date of termination, and it's to compensate the agent for the loss of that value. So the valuation exercise involves an analysis of the agent's income stream and assessing what a hypothetical purchaser would pay for it. And as Suzanne mentioned, unlike indemnity, there's no cap applied to compensation claims. So in theory, a claim for compensation is unlimited. The usual approach to calculating compensation is a capitalized earnings basis, which is taking the net annual earnings of the agent and applying a multiple. The basic formula for calculating compensation is to assess the annual income of the agency based on commission income or whatever remuneration the agency receives. You deduct from that figure future costs of running the agency, including expenses and a notional salary of someone to come in and run the agency, which would be borne by a hypothetical purchaser. You apply a multiple, which is then applied to the future earnings figure that you've just calculated, and the multiple depends on different factors, including the future performance of the agency, profitability and sustainability of a principal's business, security and supply of goods, and the size of the agency and prospects for the future. So it's a complex exercise, and valuing compensation requires input from a forensic accountant, especially if the case goes to court. And so we do always recommend that principals seek advice on these matters before negotiating a settlement figure with an agent. So before I hand you back to Suzanne, I just wanted to touch upon low earning agencies briefly in the context of compensation claims. So I've discussed, for the purposes of valuing compensation, it's always assumed that a hypothetical purchaser exists and that there's a market there for the sale of commercial agencies. However, there's actually no assumption that the agency has value to base a compensation claim, and the agent has to prove that the agency is valuable. And that can be difficult for low earning agencies, and that's in the following ways. As I set out, the compensation calculation requires deductions from the net income, from the gross income figure for expenses and a notional salary. So if an agent doesn't earn very much to begin with, then it's possible that the net income figure might be zero or negative once expenses and salary are deducted. Secondly, a very low net income figure will obviously have an impact on the multiple, since the agency is arguably not very profitable at all, and therefore it's harder for the agent to justify a higher multiple. And finally, there's case authority where the court has, in certain circumstances, decided not to award compensation at all, in circumstances where an agent earned so little that there would be no realistic prospect of a hypothetical purchaser buying it. So the key takeaway here is that agents are likely to automatically assume they're entitled to bring a very valuable compensation claim against their principal, if their agency is terminated. So whilst a compensation claim might arise, the principal should be very careful in considering how much the agent earns per year in comparison with how much time the agent spends on the agency, because it might well be that a compensation claim is simply not feasible, where an agent commits most of their time to an agency but earns very little commission from it. So I'm going to hand you back to Suzanne now, who's going to take you through the final section of the webinar before we move on to our Q&A section. Thanks very much.
Thanks, Rob. I'm just going to conclude with a brief look at a principal's liability to subagents. Subagents are often engaged by a main agent, or sometimes referred to as the managing agent, to assist in the sale of the principal's goods. There's two termination scenarios which should be considered. The first is where the principal terminates the main agency, and therefore the sub-agency is automatically terminated as a result of that. Or it may be that only the main agency actually continues, but the sub-agency is terminated. In both scenarios where you have a termination of the sub-agency, it's often asked whether the sub-agent can claim compensation or indemnity from the principal under Regulation 17. And the short answer to that question is no. And the reason for that is actually very simple. The sub-agent has, or say usually has, its contractual relationship with the main agent, and there is no contractual relationship between the sub-agent and the principal. And what that means is that the sub-agent is not a commercial agent for the purposes of the regulations, and is therefore not afforded the protection that Regulation 17 offers. And as a consequence of that, the sub-agent is not entitled to claim against the principal under Regulation 17. So that's good news for principals. Now, whilst a principal doesn't need to be concerned about its exposure to subagents, therefore, upon termination of either the main agency or the sub-agency, I will just add, for the sake of completeness here, that the sub-agent may be able to claim a share of the main agent's compensation or indemnity payment in certain circumstances. But it's important to recognise that is a claim by the sub-agent against the main agent and not against the principal. Because that's a matter between main agent and sub-agent, I don't propose to consider that in further detail today. But I appreciate that there may be some of you attending today who are possibly agents yourselves, or maybe main agents who retain sub-agents, and therefore this issue may have more relevance to you. So if anybody does have any questions relating to this or would like further information about this, then please do not hesitate to contact us after the webinar today, and we'd be more than happy to have a separate discussion with you. And that brings us to the end of the webinar. I hope you've all found it useful. We are going to have a question and answer session now. So if there are any questions that you do have, please put them in the question and answer box, and we'll try to answer as many of those questions as we can. And finally, just as a reminder, we have recorded the webinar today, so you can always refer back to the recording for any points that you may want to recap on. So I just quickly have a look at the questions and then we can crack on. So we did have one question which was submitted prior to today's webinar from Dennis Godding, and that question was slightly off topic, but very relevant to agency law currently, and that is that in light of the government's announcement to scrap EU law by the end of the year, will the Commercial Agents Directive be automatically consigned to the dustbin? And if so, will this remove all requirements for a principal to pay any form of compensation or indemnity. So you may be aware that there is a bill currently passing through Parliament to review and potentially revoke English law, which is derived from EU law. That law currently has been adopted since Brexit, called retained EU law. So the idea in the bill is that all of that EU-derived law will be reviewed during the course of this year, and then either retained or possibly amended or revoked. And there is quite bizarrely what we call a sunset clause, which means that by the end of 2023, if the legislation hasn't been retained or amended, then it will just automatically be revoked. Now, the position with the bill is that it's going through the stages of Parliament. It's highly likely that the bill will be amended along the way. And I think the current thinking is that it's unlikely that the current timescales will remain as they are. They may well be pushed back, but it is unknown at the moment how things are going to pan out with that. So there remains a possibility that the EU directive and the English the English commercial agency regulations could be scrapped by the end of the year. But there is going to be significant lobbying by the working groups to try and retain the regulations. However, they may end up being amended and take a slightly different form. If they are completely revoked, then yes, it would mean that there would be no liability of principals to pay compensation or indemnity to agents upon termination. But if the legislation is retained or amended, then there may well still be some liability of principals. So I hope that answers the question, and really it's just a case of monitoring that bill as it passes through Parliament and monitoring any developments as far as the commercial agents regulations are concerned. Rob, can I hand over to you to deal with the next question?
Yeah, it's from Dennis again. So Dennis says, if an agent is trying to decide if they can actually afford to retire, are they entitled to ask the approximate value of compensation due without actually giving notice? So I think what you're trying to ask there, Dennis, really is an agent entitled to ask the principal to give the agent a value of compensation, and the answer to that is no. There is no obligation for a principal to value a compensation claim for an agent. That the claim for compensation is for an agent to bring. However, I don't think that there's anything wrong with having a conversation, so long as the conversation is couched as without prejudice, and it's simply an exploration of how a claim for compensation might be settled, and it might be helpful in circumstances where an agent actually has quite a high value agency, and there is a likelihood that the agent will bring a claim and instruct solicitors, which will increase legal costs. So if you can have those conversations and narrow the issues before that happens, then that can be beneficial. But in answer to your initial question, no. There is no. Well, an agent is entitled to ask for it, but a principal isn't obliged to give an answer. So I hope that's helpful. Suzanne, there's another question there. If I could.
Yep. That's fine. So the final question is that a contract states that commission will be paid for a period of 3 years following termination. Will the courts respect that clause? I think the simple answer to that is yes, provided the contract can be shown to be binding between the parties, and provided the clause is clear and unambiguous, then there is no reason for that clause not to be upheld by the courts. what the main point here is that a principal cannot depart from the entitlements in the regulations so as to prejudice the agent, but it's certainly open to an agent and the principal to agree more favourable entitlements for the agent, which agreeing a period of 3 years for commission to be paid following termination would certainly be a more favourable entitlement for the agent than that provided for by the regulations. We have one final question from Richard. Rob, do you want to?
Yeah, that's fine. It's something that we actually encounter a lot. I just have to be very careful here, considering I haven't fully looked into it. So, but Richard's asked if we engage an agent based in Europe, which law would apply, UK or EU? I think the question really is which member state's laws apply. The UK used to be a member state, which it of course is no longer, but it still implements the regulations, the EU legislation. So each country will have their own version of the regulations, which are broadly similar to the EU directive. So in answer to which countries' laws would apply, I mean, it just depends. If there is a written agency agreement with a choice of law clause, then that clause should set out which countries' laws apply, and then that would be binding upon the parties. If there is no written agreement, then I believe the default position is where the agency is performed. So if the agent is based in the EU and sells to EU customers and performs all of the activities, say for example in Italy, for example, then it's likely that country's laws would apply because it's closely connected with the performance of the agency. And also if the agent's based in a country in Europe, i.e. the agency business is registered there and the agent resides there, then that would be a good argument to say that the EU countries' laws apply. So I hope that's answered your question. I mean, I can certainly, if you wanted to email me separately with more detail, I can run that analysis more accurately, but that's a sort of a broad overview of the position.
Thanks, Rob. That brings us to the end of the questions. Thank you for everybody for submitting those. Hopefully they are helpful to everybody who's listening today. And so again, thank you for everybody for attending, and we do hope it's been useful, and we look forward to seeing you again at future webinars. Thank you.